I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are bringing you another compilation video, our 19th compilation video to be exact. And if you guys follow this channel, the compilation videos have been doing well. You guys are loving them. I'm loving that you're loving them, and I appreciate all the support that you guys have shown to the compilation videos. And once again, I'll say this and I'll keep saying it. To my surprise, many of these proceedings, a lot of you haven't seen, so that makes it even better. But if you have been following the compilations, on our last one, we stuck with a theme, right? We brought you sovereign citizens who came to court with a sovereign citizen script to try to get out of paying child support. Well, guess what? Today, we have another theme. We have sovereign citizens that have come to court with their sovereign citizen script and trying to use that script to get out of paying credit card debt. So today we're going to be in 3 different courtrooms. No, excuse me. Actually, we're going to be in 2 different courtrooms, but dealing with 3 different sovereign citizens. So first we will be in Judge Victoria Shackelford's courtroom out of the state of Michigan. And for the last 2 proceedings, we will be in the courtroom of Judge David Robinson, also out of the state of Michigan. So before we jump into these proceedings, just know that there will be no commentary at the end. There will be chapters added to these videos just in case you want to, or to this video, just in case you want to jump around. And with that being said, it's time for me to get out of the way so you guys can get into these proceedings. So let's go ahead, guys, and jump in.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, you know, I've been researching the law and, you know, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and, you know, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, you know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an
But
email
Mr.
this morning.
Chavez, you're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those
So,
are the questions.
okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm
No,
entitled to rights to.
no, I'm not buying that. No. Listen to me. Listen.
It's not about, I have this, I'm going by the law, Your Honor. I'm not just making up
No,
anything.
you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time and I was going to file one, but this hearing was a little bit too early. The motion would have had been filed the next day. So I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay.
My clerk's indicating. So
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience. So that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay, all right, here's what we're going to do. I'm setting a date. So what do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P numbers 82443.
And your name, sir?
Name for the record is I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant virtually none of which I understand. So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay, so then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something.
What
I did respond. I did respond to the courts and to the complainant.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
Okay. Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you want, you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186-783, JP Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of JP Morgan Chase.
Bar number
82443.
And your name, sir?
Marcus Campbell and special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022. A series of responses, as it were filed, the last of which is a response to plaintiff's counter defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge, there's one other thing. He suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because the defendant has agreed that he owes the money.
Mr. Campbell, your response?
I disagree, and I'll stand on my brief.
And you stand on your pleadings? Okay.
Which was
all right. The court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court's register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. We are on the record. We're calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Marcus Jamel Campbell, special appearance.
First thing I want to know is Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirshenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr. Campbell, my question to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
Right.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with a genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the court had the opportunity to read your brief, and I thought it was an interesting set of matters that you set forth here, but I'm prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's
That's all I-
filed here, and I
Yes,
see
sir.
all.
That's all I need to know.
I know, for example, that you cite federal rules of civil procedure. I
Right.
know, for example, that you cite 28 USC 2403. I
Mhm.
further note, you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor, there is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
All right, this is case number 22196913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference. I'm looking for Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. All right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right now, anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my fee schedule is on the record. That's all I need.
All right. What I've received, and I've received your answer to the complaint in this matter, as I've indicated previously. That was filed with the court on March the 10th, and that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13, 23. Defendant in this matter, Marcus Campbell, or anyone representing Mr. Campbell. If you're on the Zoom, please say something at this time. The matter set on for 9:30 a.m. It is now approximately 9:39. Let me ask you, counsel, have you had any contact with Mr. Campbell? Any response to the motion for summary disposition? Update me on any information that you may have at this time.
No, Your Honor, no response to the motion and no contact from defendant.
defendants failed to appear. Moreover, in reading the motion and the issues raised thereby, as well as the predicate history of this particular or these particular transactions herein, I don't see that there is a genuine issue of material fact in this matter, and that defendant, I have to conclude that the plaintiff is entitled to judgment as a matter of law. Moreover, I do not see where a defendant has raised a valid defense to the claim. And so the motion for summary disposition will be granted at this time.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So
Mr.
we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I opened written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst, I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they sent me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said that
don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written requests for discovery, you have a right to do that too. You can send written interrogatories, requests for production of documents, and requests for admissions. Same as her. All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compel benefit or unrevealed contract or commercial agreement without prejudice.
You're gonna wipe up all those crayons you just spit everywhere?
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking you if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland Creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
I'm not threatening you. Say one more word and that's 30 days. 30 days.